This is Transqat. What is Transqat? Transqat is a safe space. It's a place for respectful conversations about transgender issues. It's a place for queer people to come tell their stories. I'm host Clare McCarthy. Welcome to Transqat. What do you do when your coworkers create a toxic environment around your gender presentation? I don't mean the occasional unintentional misgendering, but a systemic pattern of behavior. On Facebook groups, I regularly see threads about the frustrations of dealing with HR and the fear of losing a job because of speaking up about transphobia. How about if your child's school or your health club is resistant when it comes to accommodations like locker rooms or bathrooms? Where do you go? As the philosopher Ray Parker Jr. once posed the question, whom are you going to call? Well, here in Connecticut, that call might be to the Commission on Human Rights and Opportunities. Their mission, and I'm quoting from their website here, is to eliminate discrimination through civil and human rights law enforcement and to establish equal opportunity and justice for all persons within the state through advocacy and education. I'm joined today by Jessica Kohut, an investigator for CHRO, and Robin Trepanier, a human rights attorney with them.
My name is Robin Trepanier. I am a human rights attorney with the Connecticut Commission on Human Rights and Opportunities.
And my name is Jessica Kohut. I'm an investigator, human rights representative with the Commission on Human Rights and Opportunities.
Now, Jessica, you and I met at a presentation at a local public library, and you stopped in to give folks sort of an overview of what the CHRO does and the services they can present. Why don't we start there? Give me just an overview for folks who are not familiar with the commission.
Sure. And again, thank you for that. I was really glad to attend your event, and I was hoping just to leave some brochures, but really appreciated that opportunity. The Connecticut Commission on Human Rights and Opportunities, we are the state civil rights law enforcement agency. What we do is receive and investigate complaints of unlawful discrimination based on protected class in employment, public accommodation, housing, credit. So if an individual feels that they have been discriminated against on the basis of, say, for example, one's race or color, gender, disability, religion, sexual orientation, gender identity and expression, whether at work or, as I said, public accommodations or in housing, you can come to us, file that complaint. We receive it. We mediate complaints. We investigate complaints and enforce the state's civil rights law.
Which, in the case of LGBTQ rights, and particularly trans rights we're talking about with this show, Connecticut has some pretty solid protections in terms of employment, in terms of housing. That it raises the question of de facto versus de jure. What's on paper versus the way it's working in the real world. So what does that look like in the real world?
Robin, you want to take this one?
So I think that when we're talking about gender identity and expression, I think there's like a lot of intersectionality that causes a lot of, at times, chaos that shouldn't really happen, right? So we have, like, for example, school types of situations, competing interests of people's discomfort and, their religious views and things of that nature. And so, unfortunately, sometimes folks can feel very strongly one way or another, but our commission values each protected class and each rights the same. And so we are making sure that we enforce those, complaints as any others. But unfortunately, Jess and I would be out of jobs if there was no more discrimination, though I'm sure both of us, we've been doing it for a long time. We would be thrilled that that is the case because we both feel very passionate about what we're doing. But it's really a complaint-based system, for the most part, how the CHRO operates. So somebody has to come to us and say, I think I've been discriminated against based on if we're talking about gender identity or expression in this situation, but like all the other protected classes that Jess talked about as well, then we would look into that. There are some other areas that we can talk about a little later where we might jump in where somebody did not file a complaint. But that's basically how we operate. And so Jess is really at the front lines of taking in those complaints. And then I'm in the legal department and sometimes I can give like maybe an overview after about some of the things, more specific legal issues. But I think it would be great if Jess could tell folks about how folks can file complaints with our agency, and then I can give you an idea of some different types of cases I may have seen that might be interesting.
To start, two points, I think, immediately. One, where one would file. So with what regional office, and we have four. So we have the Southwest region in Bridgeport, we've got West Central in Waterbury, Eastern in Norwich, and then Central or Capital in Hartford. Where one files their complaint is dependent on where the alleged discrimination is said to have occurred. So, for example, like Fairfield County is served in great part by the Southwest region, and so you'd give the Bridgeport office a call. Most of the time, complaints are filed when we set up an appointment for you to work with an intake officer. They're going to sit with you and assist in drafting a complaint affidavit that's going to capture all the key pieces, the who, what, where, when, and how it unfolded, and why you believe a discriminatory act based on a protected class occurred. When a complaint is received to be filed, the next step is that it would be served on the respondent. So in this case, the entity, the company or entity you feel was part of that discriminatory act. A crucial piece is that, generally speaking, most complaints need to be filed within 300 days of the alleged act. So it'd be 300 days from the day you filed backwards in order to be considered timely. So once a complaint is served on the respondent, they have a period of time to provide written answers addressing each of your allegations. And this is how we're going to build the case file. So we'll have the complaint affidavit and then answers to the complaint. Those are generally 30 days after complaint service. The next step after that, when the commission has received the answers to that complaint, we have a case assessment review, which is going to determine whether or not a complaint is going to be retained for further processing. When the decision to retain a complaint has been made or not retain a complaint, for those that have been retained, the next real kind of interactive step between parties is going to be a mediation. So a mediator will be assigned to facilitate a conversation or a discussion between parties to see if we can't find a resolution to the issues raised in that complaint short of a full investigation. When that's not successful, or if that's not successful, your complaint will be given to an investigator. There's different methods of investigation. Fact finding is most common, but to investigate and collect evidence as to whether or not there is a reasonable cause to believe discrimination occurred as alleged. So that's what we're trying to figure out for the investigative stage.
If I were to come to you, one of the fears I think I would have is how cumbersome is the process. I mean, I get anxiety when I have to go to the DMV. Walking in with this for somebody who has no law experience, I think I would be a little intimidated. What do you tell folks who come in not really sure what the process is going to be like?
I feel like one of the very first questions I'll get from a person calling us the first time and looking to kind of feel out what the process is to decide if this is something they want to initiate is, do I need an attorney? And the short answer is no, you don't need to be represented. You could certainly choose to be, but it's not a requirement. I think the reason why I think it's important for folks to know is that I feel like our process is intended to allow a person with no legal experience or no representation to still navigate through all these steps and pursue whatever justice or remedy there may be at the end of the line. I completely understand if a person were to find, say, a fact-finding conference to be intimidating. You'll feel like you're kind of sitting across from a company with their attorneys and all their witnesses, but your investigator is a fact-finding party. Their purpose is just to collect information. Enter these conferences with an understanding of what happened, tell the truth, tell your story, so that your investigator can get that information as necessary and move on from there. But I do think there is a design in the process that is to allow folks to be able to navigate it regardless of their experience level.
I find a degree of comfort in you saying that mediation is an important step in the process. Do either of you have a sense of how many, of these cases end up getting resolved by that level?
I'll bounce it back to Robin for this one.
So I don't have any actual percentages. I would have to run a report, and I am not the numbers person. Shout out to Spencer Hill, who would be getting that request if we needed it. So this is just Robin's guess, right? Based on her years of being there, of being at the commission. I would say at least like 85% or 90 resolved before going to public hearing at the commission. So that's not talking about people who decide they want to go to court separately, right? I'm talking about the cases that stay processing with the commission. I feel like it's a very high percentage that they will resolve at some point prior to a full-fledged public hearing in front of an administrative referee. So, and that's the best case scenario because you have control over the outcome. Both the parties have some control over what the end result is going to be, as opposed to somebody else making a decision for you. So, resolution is always a really great option in any type of legal matter.
I think going into something like that, that's what someone like me would want. I don't want a long drawn out thing. Here's the problem. Could somebody help me resolve it? Be it my employer or my landlord to actually hear me and we resolve it respectfully.
Yeah, and I mean, we can't force, I'm sorry, Jess, we can't force parties to resolve, but there's a lot of stops along the way to encourage that.
Yeah, no, absolutely. I can completely understand why folks would, that there would be a benefit in trying to have some agency in resolution versus it just kind of slogging its way through till somebody makes that call on your behalf at some point down the road.
What do you guys tell a complainant who is afraid of retribution, who is reluctant to put themselves in that whistleblower position, particularly if you've got you're talking about a large employer, a corporation, or something that's just imminently more powerful than the individual?
When I do hear that frequently, especially during those initial calls, people expressing apprehension about filing a complaint, particularly if they're in a situation where like, I still work for this company, what's going to happen to me if I file this complaint? And the two things I can really say to them are, number one, it's always your choice whether to file. It's your decision. If you want to move forward and initiate our process, that is your right, and that is your decision. If you choose not to, that's also absolutely your choice. If one believes that they are experiencing retaliation for having filed this complaint or for having participated as a witness in the investigation of somebody else's complaint, for example, that would be grounds to return to the commission to initiate the process again on those specific incidences, if you chose to do that. Certainly, I hope that would not be the case for one filing their complaint, but if there is, that's the recourse they would have if they wanted to do that.
Let me start. I'm curious about all the different aspects of your work, but let me start with the workplace. What kinds of issues, and I understand that we can't speak about specific cases, but what kinds of complaints are trans, non-binary, gender fluid people bringing to you in terms of the workplace?
So some things that I can just think of offhand is I kind of feel like most discrimination cases can have a flavor of like hostile work environment or harassment. So what would that be in a trans type of situation? Misgendering, not, respecting the person's pronouns, dress code requirements, and things about, not accepting, what somebody is identifying as health benefits or benefits at the workplace that are offered. So I think that those are typically like the most general, like, my employer is treating me differently because of my gender identity is probably the most typical type of case that you might see a trans person file, but there can definitely be some more nuanced type of situations.
Facilities, like bathroom access, changing room access, does that sort of thing come up as well?
So that is definitely a huge issue in a lot of different places. So whether it's employment, schools, gyms, facilities, we've actually had a case that was about gyms, and it actually was about a woman's workout area, but it touches on this idea that there was not an exception in the law to create other places. So the places, facilities are allowed to have separate men's or women's changing areas and restrooms, but also you have to allow the person to enter the one that they identify with, who's going to be policing that. And, how are they policing that is often, the issue. And so on the very basic level for an employer, they need to allow, the employee to choose the facility that they feel comfortable going in. It could be a larger issue, though. It can be spread to a lot of different facilities.
It's not an employment thing, but I was looking at a news story about a 2022 case that you guys dealt with 3 of the gym franchises in Connecticut, and they're women-only spaces.
Well, that's the case that I'm talking about.
Oh, okay, cool.
And it's the idea that there's not an exception. So we have this idea that everybody has access equally, right? And so while we can recognize the reason for having a women's only area in the gym, there's no exception that was like created under the law for that, right? There's an exception created under the law for men's and women's facilities in terms of changing rooms and restrooms, but there's not an exception created under the law. And so that's where, it could be problematic, especially when we're thinking about in terms of who is going to be policing it, right? If you're talking, when you're making a women's only facility, let's be honest, generally that's for like cisgender white women to use.
Right.
And so who is potentially maybe discriminated against is people who don't present as cisgender white women. And so that's where, even though like the case was not necessarily a trans case, there's this like kind of intersectionality and how it kind of plays in to the other facets. But that's the case that I was talking about. And, at the time, the Connecticut Supreme Court decided that it's up to the legislature to decide what exceptions can be created under the law and not the private place of accommodation. So the gym was a place of accommodation. So the gym just can't say, I'm going to create this. The legislature, such as they did with changing facilities, has to carve out the exception. That's it in a nutshell. And I'm not the expert, but we could definitely too, if you ever have an interest in these areas, we can set up another talk with some folks from legal who even they, argued the cases or briefed the cases. So I'm giving you the nutshell version.
What about housing? So I'm a homeowner, so I don't really answer to anyone, but what about dealing with landlords, or does this include dealing with like mortgage companies who are going to determine whether or not you can get access to the money to be a homeowner?
So I used to be in housing, so I will take this one. So housing is a really vast area where employment discrimination is really just against your employer. It's very kind of limited. Housing is quite vast because, like, think about it. That's the place where you want to feel safe. That's the place where you want to feel protected. And everybody, has the right to have safe, comfortable housing, which is why it's such a sensitive subject. So housing is not just limited to like the housing provider, but it's covered by landlords, tenants, mortgage companies, financing companies, but even neighbors. So if you, so if you, as a trans individual felt that you were being harassed by neighbors, and, that is something that it could be against the individual neighbor if you think it's based on that protected class basis. Of course, it's always harder litigation against an individual because what is the end result of possible remedies? It's hard to stop somebody's bad behavior. So sometimes it's like you quantify things into damages and it could be hard. if we're talking about damages with an individual, but the law is designed to protect against that type of behavior. So it can be real estate agents, the law it applies to them as well. So in housing, it's very, very, very vast, I would say, is the protections. And even in terms of renting, or terms and conditions of somebody's, if you have a homeowners association, there could be different terms and conditions there. So I think even though you might be a homeowner, there's still, aspects where you're still covered.
Jessica, let me see if I can bring you back in on this. What do you see? What do you deal with in terms of schools? Because that was the other big area that I was curious about. We've got we've got employment, you've got housing, but instances of bullying or perceived bullying or a lack of receptivity on the part of administrators. What sorts of things do you see along those lines?
Of the school-based complaints I've received either through an intake process or as an investigator, I would say that they tend to focus, at least thematically, on an issue of equal access to services. So, for example, like a parent is filing on behalf of their child because their child, for example, has, say, a disability, and they don't feel that the school is working to meet that child where they need to be met. I'm also really happy to say that in my time, I have not seen a huge number of school-based complaints, whether, bullying or what have you. I hope that's because it's not happening much, though. That's my hope. So, I have to be honest and say that my experience in that arena is pretty limited. Though, if we were looking at topics like, for example, child thought that they were being bullied or harassed at school because of their real or perceived sexual orientation, their real or perceived gender identity and expression, these would all be grounds, of course, to engage the commission. And here, just as like a mechanics piece, I guess I'll call it, when someone is under 18 but still looking to initiate the commission's complaint process to remedy a situation that they believe they're experiencing, then you would just have a parent or guardian filing on their behalf. Is the only part I'd add there.
Is there for a student who feels that something is wrong at school, is there a sort of a hierarchy of steps that they need to go through before they get to you? Does there need to, do you need to have, let's just as a theoretical, let's say that a student has a teacher who is not doing a very good job of using the pronouns or is using the dead name. Are there does the student/parent need to have tried to address it with the teacher, then the school administrator, before reaching out to you guys?
My initial thought is if I were receiving that question as a duty call to my region, my initial reaction would be, let's schedule you an appointment to file. That said, I'm going to jump back to Robin to make sure I wasn't wrong there.
So are some education cases that there's like an exhaustion requirement, and I would say that, and I'm just scrolling because I just read this earlier today, that does not apply to bullying types cases. The Commission and the Connecticut State Department of Education issued some guidance to schools on, tell you what the title is instead of guessing, civil rights protections and supports for transgender students. And there's also frequently asked questions. You can share it with your listeners or share it for anybody who needs it as a resource. So the thing that it suggests in the guidance is that it is good for students and parents or guardians to report the discriminatory treatment to the schools because they have the responsibility to address it, and they're usually in the position to take the most corrective action. That's one of the problems. So yeah, the CHRO is here and we want to help, but we're not an emergency overnight problem solver either. And so to the extent that the school is going to respect the issue and address it, they hopefully would be able to nip it in the bud right away. And so while that's not necessarily a requirement that they have to go through these different steps, there's definitely also, the school needs to know, because they're in the position of, possibly being held liable for their inaction based on the complaint. But there's a lot of resources available to the schools too on how to learn to handle things appropriately. And then is also, so they can file with us at the CHRO, and they can also file federally with the Office of Civil Rights. So in the fact sheet, in the guidance, all the contact information is in there. So I would say, to answer your question, I would suggest definitely reporting it to the school so that they're aware of it, but you don't have to go through, a bunch of hurdles before you can come to us.
Is there a point in resolving these issues, be they housing or workplace or school, where education is a part of it? Because I can see a well-meaning business person, landlord, school administrator, although you would hope school administrators have an HR person who could explain all this to them. Is there a point where there really needs to be some group education here? We'd like your company to set up some trainings. We'd like your faculty to sit down with this person and see if we can't raise the level of awareness.
So I can say that I have, in my experience, part of resolution of different complaints that I've helped mediate or resolve. It's included a piece of requiring training, and the commission does offer training. So, whether parties want to have that training issued by the commission, that's absolutely a possibility. They want to bring in a different training source or vendor. But yeah, in mediation experiences, I've seen that be like a stipulated part of resolution agreement.
I would say in housing, it's almost always a requirement that there's be some affirmative type of policy relief. Because again, like I said, that there's just this really important aspect of your safe and comfortable housing. And HUD has requirements that there's affirmative relief. That's what we call it as well. But it's usually some type of like training or monitoring or a change in policies and procedures. It really depends on what their violation was. But very often there's affirmative relief. And that's something that also, if the unfortunate circumstance that, we can't resolve it voluntarily during mediation or a settlement conference, hearing referee can also issue affirmative relief. And so that is often something that we talk about. Definitely there's a lot of training opportunities. We've done like trainings on bullying and things like that in schools. We've also done like programs for younger children in schools to try to like prevent some of the things. So I'd say that is often like one of our main missions. I think is a lot of outreach and education, because we'd rather folks not get discriminated against, and we'd rather folks learn and do the right thing. You know what I mean? That's at the end our one of our major goals. We don't want people to be discriminated against, and the best way you could do that is with education. You're going to have some bad actors, but there's a lot of people that don't know and they act out of ignorance and unknowing, which isn't a defense, right? That doesn't make the person who was harmed any less harmed, but it also, there's a way to try to remedy that, and by teaching them and going forward, they hopefully won't do it again.
I do a fair number of speaking engagements, and consistently I get not so much resistance as, oh, I didn't understand that it was even an issue. So tell me what I can do so that I'm not offending trans people, or so that I'm not causing harm. And it really is just a process of education, I think, for the vast majority of people out there who would just as soon run their business in a considerate way. They're just not familiar enough with the issue.
To that end, just a quick shout out to our really remarkable diversity and equity and inclusion committee through the commission, who do phenomenal social media posts and education pieces that are put out there all the time. You can find them on Facebook and Instagram, and you can find them just phenomenal work, and really kind of taking up the charge on education and outreach in that way. But yeah, to that point, education is a huge piece in a lot of what we do, and just expressly there in our mission as part of why we exist and what we're trying to accomplish.
Talk to me a little bit about the teeth that the CHRO has, because we're sort of leaning towards the best possible resolution. How can rational people who want to reach a civil resolution. But what happens when there actually is an antagonistic situation? What sorts of resources do you guys have to hold bad actors accountable?
So, like I said, if a case stays with the commission, though, these laws can also be our laws, anti-discrimination laws can also be litigated in court. And something that we talked about earlier, which is our process is designed to be pro se friendly. There's no cost to filing with us. Not like when you go to court, you have to usually pay a filing fee. So we are designed to be able to be pro se friendly. And if there's a finding of cause, so it gets through the process that Jess was talking about earlier, and the investigator decides that it looks like there's reasonable cause, that's our standard, to believe discrimination occurred, it then would be certified to the Office of Public Hearings. If the individual, the complainant, is not represented, the commission will prosecute the case. So we will prosecute the case on behalf of the state, but the idea is our interests are aligned then with the complainant who has a cause finding, because the complainant has been harmed by a violation of our anti-discrimination laws, where we, the commission, are upholding those laws, and therefore our interests are kind of aligned. And so we work with the complainant to prosecute the case. So again, when we're talking about, comfort level and whether you need an attorney, you have the right, and they could prosecute the case for you. We would stay involved to make sure the public interest aspect is also still being addressed. So we'll prosecute that case. And then there's a variety of statutory remedies, and it kind of depends. I was going to bring up the statute, but it depends on what type of case it is, whether it's employment. We could talk about lost wages and things of that nature. In housing, there's like lost housing opportunities, cease and desist from certain types of behaviors. There can be affirmative relief that's issued, like, training, monitoring. So there's a wide variety, which is very statutory. And then there's also can be emotional distress damages for the individual who has been discriminated against. Housing cases can also be housing specifically. After a cause finding, there's something that's called an election to prosecute the case in court. Then a housing provider, so whether we're talking about the bank, the landlord, whoever, can also be subject to civil penalties because of violating anti-discrimination laws. So there is teeth, and it can be very costly, especially since if the complainant prevails, they can get, if they do have an attorney, they can get attorney's fees. And sometimes, so let's say we're talking about emotional distress damages, which is very hard to quantify, right? It's very hard for a third person to value how much you've been harmed in something that happened. But that being said, let's say, I'm just going to throw out a number. Let's say it's $10,000. It could have been $150,000 in attorney's fees by that point. And so that the discriminator then is responsible for those fees too. And if they have their own attorney who they're paying, we're talking about, when we're talking about business, it is a lot of times about hitting them where it hurts, which is financially, unfortunately. I would say it's very different though in cases like school cases and stuff like that. We're talking a lot more about changing in policies and trainings and monitoring to make sure that they're handling complaints properly and things like that. So it really depends on the case, I think, is the short answer, but there's a lot of different ways that there is teeth to address and try to remedy the damage.
How, if at all, involved are you guys in the ongoing trans athletes in schools issue here in Connecticut? Do you guys have any toes in that water?
So we did intervene in that case, if we're talking about the Sewell case. And so we did intervene to the same side as the school districts and then the athletic district about the fact that you have to let trans athletes participate in this team or sport and section that they identify with. That I guess what happened. And again, like I said, we could set up another session for one of our experts to talk more about this. But it was like originally dismissed, and we had joined in on that, and we were in a brief on that. And then the Second Circuit decided to hear it all over again, which is like, I guess, very rare and very unheard of, but that's what happened. And so, we still think that that's going to go further. But the idea where our point is that regardless, and we also have to think like there's some concern about there being conservative Supreme Court at this point, right? So at some point, there's maybe less support for Title IX federally, but Connecticut, we still have those protections and we would still enforce them. And I'm just looking at my notes. I apologize. Oh, yeah. So one of the issues that's been coming up, this is where it was, that Title IX was essentially created to provide equity between the sexes, right? And then, at some point, federally, they said this also applies to gender identity and expression. And that's one of the things where I said it gets very hot topic, because we're talking about there's this one group of people that say like, hey, women wanted to there's this supposed to be this equity, and that's where Title IX was created, and we're taking it away. But then we're also talking about we can't say that one protected class is more important than another, right? And that's where people feel very passionate about it, and it is such a hot topic. So it is something that we still might, see some more of as the time goes on.
Did I see correctly that you guys have a new commissioner as of about a month ago?
We have a couple of new commissioners that have just been brought. So our commission is they're volunteers. They kind of sit and make certain decisions for the agency. And there's commission meetings that are once a month, which is different than commissioners, which a lot of agencies have, which are appointed by the governor. We have
Well, that's what I was thinking. Like you have a commissioner of education. We have, so this is an actual commission.
Yes, we have an actual commission, but we did, I believe, maybe just got 3 new commissioners, but don't quote me on that. But our director, the head of our agency, been the director for I don't know how many years, but it's been maybe 10 years.
Okay.
Tanya Hughes, and then we have a deputy director, Cheryl Sharp. And so they've both been together running our agency for a good amount of time and have definitely put in this focus of education and outreach. We've even had Kids Court is this great online program that
I saw that on the website. I wanted to ask about it.
Yep.
So what is Kids Court?
It's actually for students, and usually when it's like in session, this used to be, let me go back in time, this used to be a one-day event at UConn Law School where students would come in person. This is, pre-COVID, and we would have all these like activities and talk about, discrimination and racism, and hearing kids' perspective on things is so refreshing because they're coming from a different place, whether they're not jaded or they've seen things. And it's nice because it was all different school districts. So you'd have a kid that's, in a mostly, say, predominantly white school with a kid who's going to a very, diverse school, and you're hearing their different perspectives. And it was really, really refreshing. Then COVID came. And especially Cheryl Sharp was like, we can't just not have Kids Court. And so they started an online version. It might be Kids Speak on it. I might have a different name at this point, but the idea is it meets when it's in session weekly. I think it is on Tuesdays after school. And every week it's like a different topic. And so it'll be different. Like we've had judges and attorneys and people from like the Attorney General's office and, people who used to work for us who are judges now talking to the kids about different types of legal issues. Then we have these breakout sessions where we're talking about these, matters, and we've seen documentaries, and they've had, it's been really great. And you should see the participation. It's unbelievable when you see how excited and how bright these kids are.
Well, I think I've got to imagine that a program like that leads to an improved community in terms of government employees, in terms of attorneys and judges, in terms of activists. You have people who are more informed, because you do find very often that teenagers, they get very passionate about something, but that's kind of the extent of their understanding is I really want people to do something about climate change or queer rights, and put them in a situation where you're seeing all sides of an issue and learning debate skills and communication skills and collaboration skills. That sounds incredibly valuable.
It's really great. And when they feel this passion at a young age, because when you want to be an activist, sometimes you feel burnt out at some point, and when you're young, it's almost refreshing. It gives you, some extra energy. And, the kids, I'd say kids, but there's, middle school and high schoolers and even elementary schoolers sometimes participate, I believe. I know that we had an elementary day at some point years ago, but they're so mindful and already have the appropriate vocabulary to talk about these things, and it's really nice. So I mean, I quite honestly and apologetically forget a lot to say, like my pronouns are she, her, and hers, and they will do it right off the bat because it's already part of their vocabulary and their things that they find important.
I have to say that young people give me hope. They really, really do. When I would help facilitate for Kids Speak when it was still in person, it was something to look forward to every year that was just rejuvenating on a mental and spiritual level, to hear young people who still had these really bright, forward-thinking visions. And I'm like, okay, great, there it is. I found it again. And, perhaps beneficial to them is also putting them face to face with folks who are carving out careers and lifelong objectives and goals, doing the thing that they're presently passionate about. So it's like wonderful. Grab onto that passion, because there are things you can bring with you into your adult life and carry with you and move forward for a long time. The road does not stop at high school petitions. There's so much more we can be doing going forward.
And in terms of short-term goals, college essays have been making it very, very clear that the sort of standard boilerplate essay is being immediately discounted, that we want to hear about what you're passionate about. And this sounds like exactly the sort of program that you could participate in for a year or two in high school and come out with something really strong in terms of a college essay. Here's what we did, here's why we did it, here's what I learned. I can see that being really appealing to a college.
Yeah, I can absolutely see that. And I'm also, just on a side note, delighted to hear that sounds like they're doing away with that boilerplate essay. That's might be the best news I'll get all week.
Well, and also, there can tend to be a leg up for certain classes of people that have assistance, whether it's in their school because their school has extra funds or based on their own family's financial situation, to have like these coaches and people helping and polishing them. And, having that advantage doesn't necessarily make them a better student or, than somebody who might have a really great story and passion and intelligence, but didn't have the same, can't think of the word.
Well, it's a matter of equity, right?
Yeah.
I mean, there's equality where everybody in theory has access, but equity is the reality that all sorts of, as you said, protected classes don't.
The same resources. That's the word I'm trying to think of. The same resources as somebody else, which is then, that's where a lot of the diversity lessons and stuff come from. Because when we're just talking about access to resources, people can miss out on some of these opportunities. So I just wanted to go back to the Sewell case really quickly because I found my notes, and it was just argued a few months ago, and we're still waiting for the decision. So the Second Circuit on their own wanted to hear it over again, which was not really heard of very often. And it was argued a few months ago. We're still waiting, and I'm going to give a shout out to Michael Roberts, who is the person that I would say that when you want a deeper dive, he's the person that you should speak to. He thinks it might even end up making it to the U.S. Supreme Court. So we'll see, because it's a hot topic issue.
Final words, tell people what you want them to take away from this as far as CHRO and what it can do for them.
I think first and foremost, we're here. We are here to help you. We are here to help you find the information you need. Giving us a call just to find out what options there are and what information's available doesn't obligate you to anything, certainly call us, certainly go to our website. I know it can look like a large, daunting process, but the folks you'll speak to on the other end of the phone want to help you out. They want to make sure you have the information available. It's absolutely your right to file your complaint.
I would just second what Jess said. I think, we're here and we want folks to know that we're here. And, we want folks to contact us if they think that there's an issue, if they think that something is happening, and, we're here to look into it. Sometimes you get that feeling, and it's better to check into it because it's hard to articulate when you're being discriminated against. Yeah. It can't be, if it's not blatant, it's hard to articulate that. And, we're here to help.
I could certainly see any number of situations where you find yourself, wondering, is this just me? Am I just being overly sensitive? Am I really being discriminated against? Just the chance to reach out and see, okay, well, have other people had a problem like this? And is this legitimate? I can see that being invaluable.
So we may not be able to tell you when you call, like, yeah, you know what, this is discrimination. You should absolutely file. But, we'll listen, and we can say, and what I'll certainly tell people is that, do you believe you were discriminated against? Do you feel like you weren't treated fairly? Do you feel like something was wrong here? Because if you do, that's the line. That's the barrier to entry, really, in terms of now it's your right to file, and then we can take it from there. But, in terms of whether or not there's cause to believe discrimination occurred, it's not something we're going to know until down the line, till after investigation. But that initial, if this is how you feel, we can take it from here and help.
Thanks to Robin and Jessica. I will certainly follow up on their offer, and I'll try to put together an episode on the Soul case in 2024. Speaking of which, this is the final episode of 2023. Thank you, first of all, for listening. Buzzsprout, which distributes this podcast, sent me some cool year-end infographics. People in 9 countries have tuned in over the last year. The show saw a 161% growth rate. I am uncomfortable enough with numbers that I don't exactly know what that means, but it sure sounds good. And it turns out Middletown is the location with the most downloads, so thank you to the Forest City. Coming up in January, we have my presentation with Tony Ferriolo to benefit Alex Inc. There's a link on the events page at transqat.com. Ditto for game night. New date, new location, but you can find that on the events page as well. If you're attending TCNE's first event in Boston, I'll be in the vendor's room on the 26th and the 27th, and I'll be recording your stories during 2 sessions on Friday. Hope to see you there. Lots of great stuff coming up in the new year. Next episode is a conversation with Rowan Jete Knox. Your homework is to read either or both of his books, Love Lives Here and One Sunny Afternoon. This has been Transqat. I'm Clare McCarthy. Thank you for listening, and let's talk soon.
This is Sadie McCarthy. I'm Claire's niece.
And you've just been listening to Transqat. It is made by one of my favorite people in the world, Clare McCarthy.
Transqat is a production of Transqat Enterprises, LLC.
Copyright 2023, all rights reserved.
Join us on the web at transqat.com.
That's TRANSQAT.com.
QAT.com.
QAT.com. There you'll find links to Transqat, the blog,
writing projects,
speaking engagements,
and our PayPal donations page.
Please consider supporting our mission with your monkeys.
Monies.
Your monies.
Your monies.
Not monkeys.
Please consider supporting our mission with your monies. Any monkeys will be gratefully received as well.
Follow Transqat on Instagram, Facebook, Twitter, and YouTube.
On TikTok, we are at The Real Transqat.
Want to tell your story on air?
or ask Claire a question.
What is the deal?
She has all the answers.
Or suggest a guest or topic for an upcoming episode.
Use the contact page at the website
or email her directly at crmtranscat@gmail.com.
crmtranscat@gmail.com.
And thanks for listening.
Thanks for listening.
Thanks for listening.
Thank you for listening.
Thanks for listening.
Thanks for listening. Bye.